Welcome to the Hip Talks podcast, a series of discussions about current legal issues hosted by Hugill and Ip solicitors. We are a young, independent law firm, but with decades of experience providing bespoke legal advice and exceptional client service to individuals, families, entrepreneurs, and businesses, both in Hong Kong and internationally.
Today we are going to talk about dispute resolution and alternative dispute resolution with the Hugill and Ip solicitors. Okay, so I am here with Adam Hugill to just have a really brief introduction into what is dispute resolution. So Adam, what do we mean when we refer to dispute resolution?
Dispute resolution is the means by which we formally resolve a dispute, often referred to as litigation, but it can take many forms. The most common form for people would be suing in either district court or high court in Hong Kong, but it can also take place in many other forums, which relate to for resolving specific disputes. And so for employment matters, they would be dealt with by the Labour Tribunal. There's also the Lands Tribunal. And also arbitration falls within dispute resolution as well, which is essentially a private dispute resolution system.
So if I wanted to commence a legal action, what would I have to consider? What should I be considering? Okay,
the thing that most clients want to have answered up front is certainty. They want to know that if they bring a dispute, that it's going to be resolved in their favour. And in certain cases, that can be very easy to advise. If it's a contractual dispute, for example, and the contract is very clearly written, it's been breached, then we can give the client some certainty as to their success in a dispute resolution process. Often, though, the reason why the matter has gone to a court is because there is some uncertainty in it and a dispute between the parties. And ultimately, at the end of the day, this falls to be resolved by a judge. And you can never give clients 100%, you can never advise a client that they have a 100% chance of success. The other two key factors that most clients are concerned about is time. The dispute resolution process in Hong Kong, certainly if we're in the High Court or the District Court, takes a long time. And from the start to the end of a matter, if it goes all the way to trial, could easily take 3 or 4 years, and it's not unheard of for cases to go much longer than that. And then the final issue, which is of major concern for most clients, is cost. Everybody is aware that lawyers are expensive, and dispute resolution and the litigation process itself is incredibly expensive. And so one needs to keep in mind proportionality when it comes to incurring legal costs against what you might seek to recover.
So cost you've just mentioned, it seems to be a very important issue when you're considering whether or not to take legal action. How can you go about managing costs?
As I say, it's important to be proportionate. There's no point in running up $1 million of legal costs if you're only going to be suing someone for $100,000. Similarly, a client must be advised that the litigation process itself is both proactive and reactive. And while we can anticipate what might happen during the litigation process, the other side will almost certainly be using various tactics, either to improve their case or to try and break your case. And you can end up being sort of very reactionary in relation to that, and it incurs costs. The other thing that everybody needs to be aware of is that in most courts, certainly the District Court and the High Court, the loser will end up paying the winner's costs. And so from the winner's perspective, that's good because they get a substantial amount of their costs back, about 70%. But obviously from the losing party's perspective, they will have to pay their own legal costs and then a substantial amount towards the winning party as well.
So it's basically very unlikely that you'll actually ever fully recover your legal costs incurred in the proceedings.
That lends itself to the frustration of litigation, which is even if you're completely in the right and you have a very strong case against the defendant, but the defendant won't pay up, essentially these claims are for money, then you have to pursue them, and whilst you will get some costs back, it's never 100%.
That's unfortunate, but I guess must be done.
It's the process, I'm afraid.
Apart from the cost and other things that we've mentioned so far, are there really any other key concern or anything you would like to really emphasize?
For clients going into litigation, it's usually a long battle. You will have had pre-litigation correspondence or discussions, and they obviously won't have been successful, which is why you're considering bringing a case at court. The process for both sides is very frustrating. For the plaintiff, it's a big leap. You're spending a lot of money and you're taking a lot of risks, even with a strong case. For a defendant, it's not as much of a consideration because the defendant doesn't get the choice. They have to defend themselves. But the key thing to manage with the client is that it's usually a long process. It's quite frustrating, and very rarely do you end up with a perfect resolution at the end of it.
I'm here now with Jonathan Gray to talk about what takes place during a civil trial here in Hong Kong and what witnesses who are called to give testimony at a trial can expect to encounter. So, Jonathan, how long does it usually take before a case will proceed to trial?
Well, it depends to a large degree on the issues involved, the complexity of the case, and any type of interlocutory applications made along the way. So that is applications related to the case that need to be decided before it gets to trial. It also depends on the court's availability, in particular if the case is being heard by a specialist judge, say the company's judge or a construction judge. You really need to fit in with his or her availability. As a very rough guide, however, cases in the High Court typically take around 2 to 4 years from start to finish. But in complex cases, they can in fact take much longer than that.
So do all cases then have to proceed to trial?
Well, no. In fact, a very high percentage of cases, probably I would say at least 80%, never get to trial at all. And this is usually because they're settled, either for commercial reasons or very often it can be simply because people don't want to wash their dirty laundry in public.
No airing of dirty laundry. That's probably a good policy. So what should people expect when a case does go to trial?
Well, courts now require parties to file written opening submissions in support of their respective cases, which would be within a specified time frame before the start of the trial. And as a result of that, less time is now typically required for what we would call oral opening submissions or arguments made by the barristers. And similarly, courts, again, now typically require the parties to file written closing submissions rather than making oral closing submissions. So what this means is the main part of the trial actually involves the examination and cross-examination of witnesses.
What exactly does cross-examination mean or refer to?
Well, cross-examination is where the barristers on the other side get to ask questions of the other side's witnesses. Witness statements now are usually ordered to stand as what's called a party's evidence in chief, meaning that the witness is no longer required to be examined by his own side's barrister before cross-examination. So normally now what happens is a witness may be asked by his own side's barrister, perhaps to correct something in his statement if necessary. That would be fairly short, and then he would be handed over, he or she handed over to the other side's barrister to face questions.
So basically, the cross-examination will in fact be based on that witness's original witness statement.
That's right.
So what happens after they've been cross-examined by the other side's barrister?
Well, then after they've been cross-examined by the other side, the witness then is usually re-examined by their own side's barrister. And this gives the witness an opportunity to clarify certain things that they have said or to provide further context to answers that they've given under cross-examination, which he or she may not have had the opportunity to do while they were being cross-examined.
So what kind of questions would a barrister ask during their cross-examination or the re-examination?
The other side's barrister, what they're seeking to do in their cross-examination is to undermine the witness's evidence and possibly also his or her credibility. Normally they'll be asking tightly focused questions, and in most cases the barrister will know or expect the answer. And so he or she will be framing his or her questions to arrive at or to establish certain points. And often many of the questions that they're asking may only permit a yes or a no answer.
So it sounds like cross-examination or re-examination as well. It's going to be a very unpleasant process.
Yes, it's fair to say cross-examination is a difficult, nerve-wracking and fairly unpleasant experience. Witnesses often feel that the barristers examining them are seeking to trip them up and to twist their words, which of course in most cases is exactly what they're seeking to do.
So witnesses who are involved in a trial, can they watch the trial as they proceed or listen to the other witnesses while they are giving their evidence?
A witness is allowed to sit in and watch the trial, but only after they've given their own testimony. Before then, they're not allowed to sit in or watch. The exception to that is if the witness is also a party to the proceedings. And in that case, as a party to the litigation, they have the right to sit in and watch the entire trial.
Is there any particular order in which witnesses must give their evidence?
Generally, the witnesses for the plaintiff will go first, followed by the defendant's witnesses. Although in exceptional cases, normally say in the case of an elderly or an infirm witness, for the defendant, they may be allowed to give their testimony first, but that's pretty rare, to be honest.
So as a potential witness, what can they do to prepare for the trial?
Well, preparation for trial is extremely important. Before the trial, any witness should read and familiarize him or herself with the pleadings and the evidence, including the evidence of the factual witnesses on both sides, and at least as far as their own evidence is concerned. It's very important to understand, however, that while preparation is permissible and in fact very important, witness coaching, that is the coaching of pat answers to anticipated questions, or the putting of words into a witness's mouth is not permissible.
So do you have any advice for witnesses who are preparing themselves for trial?
Yes, absolutely. First and foremost, witnesses should tell the truth. They shouldn't attempt to lie or to embellish their evidence in any way to suit their case. Any efforts to do so invariably will be exposed by a skillful opposing advocate. And a witness who's shown to have lied or embellished certain matters ends up losing credibility, and that would often result in them then not being believed even when they are telling the truth. And I would also advise witnesses, if they don't know the answers to a question, they should just say so. Often they're being asked about events that took place quite a long time before the trial, and it's entirely natural that they may have forgotten certain details or become confused about certain details.
So if I've actually really forgotten something, then I should just tell them that
say
I've
so.
forgotten. Right.
Absolutely. However, witnesses should avoid seeking refuge from difficult questions by claiming in response to all such questions that they can't remember, particularly if this is about significant events that they would be expected to recall. Otherwise, they just end up looking evasive.
So how formal will these proceedings be? As a prospective witness and I'm looking around me, what should I be expecting?
Well, trials in Hong Kong still are very formal proceedings. The barristers and the judge will be in their full regalia, wearing gowns and wigs. Witnesses have to give their evidence on oath and are formally sworn in before giving their evidence. Court proceedings also require a certain etiquette to be followed. Barristers and witnesses are expected to be courteous to the court and to each other, even if they're on opposing sides. Just in terms of another piece of advice that I often give to witnesses, particularly if they haven't had previous experience of court proceedings, is that sometimes it's a good idea to visit a courtroom beforehand where another trial is taking place, just so that they can get an idea of what happens. Trials are generally open to the public, and they wouldn't need to observe for too long. Maybe half an hour, 1 hour would just give them an idea of what goes on.
So I'm here with Jonathan Gray and Matthew Love to look at some of the more commonly used methods for enforcing judgments in Hong Kong. So if I have managed to obtain a judgment in Hong Kong through court proceedings, how would I go about enforcing it if the judgment debtor, the defendant, fails to pay?
Well, there are various ways of enforcing judgments in Hong Kong. One of the main methods is getting what is called a garnishee order over the judgment debtor's bank account. That is an order compelling the bank to pay the judgment creditor a sum equal to the judgment debt plus any costs awarded to the judgment creditor, which are included in the terms of the garnishee order. Another common method is getting and registering what is called a charging order over certain property, such as land or shares, securities, with the result that, in effect, they then cannot be freely disposed of.
Yeah, so just to jump in here, I think another less common enforcement method is a form of execution against the judgment debtor's personal property, personal chattel, and that's known as a writ of FIFA. And this involves the court bailiffs attending the judgment debtor's property and seizing his personal and movable property to sell at a public auction to repay the judgment debtor.
So of the methods you've just mentioned, which one is the best?
Well, there it really depends on what assets are available and what assets are known to the judgment creditor against which the judgment can then be enforced. Garnishee orders are probably among the most favoured methods of enforcement, as these result in money being paid directly to the judgment creditor. But a judgment creditor can only apply for a garnishee order if he or she knows the bank account details of the judgment debtor, and this may not always be the case.
So you'd also discussed charging orders earlier. What about the charging orders then?
Yeah, so charging orders can be effective, but they don't in themselves grant a power of sale. A separate application for an order for the sale is still required. And, significant difficulties can arise if the charged property is co-owned by a joint owner and effectively, a sale of a charged beneficial interest is not practicable. However, there may be alternatives, such as the appointment of a receiver to receive a judgment debtor's share of rental income, for example. Seizure of chattels, of personal property, is less common, and partly because items seized may not be valuable enough to pay off a judgment debt if the judgment debt is for a large sum, for example. Also, procedurally, it is more time-consuming than other methods of enforcement. So ultimately, the best method will really depend on what assets are available.
But what if you do not know what assets are available? It'd been mentioned before, for example, that you need to know a judgment debtor's bank account details to apply for a garnishee order.
Yes, a very useful tool to assist with the enforcement of judgments is obtaining what is called an order for oral examination. Here, the judgment debtor has to appear before the court, where he or she is then questioned about the nature and extent of assets that he or she owns. And they'll have to disclose, for example, details of their income, bank accounts held, any real property, shares or securities, and indeed any other assets or property owned, for example, cars or boats or even aeroplanes. The judgment debtor will also usually have to swear an affidavit swearing on oath about his or her assets. If the judgment debtor fails to attend the court, that is after they've been properly served with the order requiring them to attend, the judgment debtor is liable to be found in contempt of court and indeed at risk of imprisonment. So as a result, oral examination can be quite a persuasive tool for assisting with enforcement and quite often can lead to a voluntary settlement as the judgment debtor may see that one way or another payment is inevitable.
It's very interesting. Would there be any other methods of persuasion, so to speak, or of putting pressure on a judgment debtor to compel them or encourage them to pay up?
Yeah, no, there are several other methods to try to get a judgment debtor to pay his debt. And one method that is commonly used is obtaining what is called a prohibition order. And what that is, it's an order preventing the judgment debtor from leaving Hong Kong until the judgment sum is paid. Now, this can be useful if the judgment debtor is taking evasive action For example, evading service of an order for oral examination, which requires personal service, and it's believed that the judgment debtor is about to leave Hong Kong and likely to cause difficulties in enforcing the judgment against him. This is a very powerful and can be a quite persuasive method, particularly if the judgment debtor needs to travel and is restricted from leaving Hong Kong because of that.
Another method of persuasion, rather than strictly being a method of enforcement, is presenting or threatening to present a bankruptcy petition, that is if the judgment debtor is an individual, or a winding up petition if the judgment debtor is a company. In both cases, this needs, first of all, a statutory demand to be made, and a failure to settle the judgment debt within 21 days then provides grounds for the presenting of the petition. The disadvantages here are, however, that the judgment creditor then loses control of the process once the bankruptcy order or the winding up order is made. Because then what happens is a trustee in bankruptcy or liquidators are appointed. They then take control over the judgment debtor's assets. And the judgment creditor takes his or her place as an unsecured creditor, meaning that they will typically recover less than the full amount of the judgment debt. But in certain cases, the threat of presenting a winding up or bankruptcy petition can be quite effective. In bankruptcy cases, bankruptcy orders potentially can have an impact on a professional person's career. For example, a bankrupt may not be able to practice in certain professions, for example, a lawyer or an insurance agent. And bankrupts working in the banking sector are required under the banking ordinance to inform his or her employer of his or her bankruptcy. While the companies, the presentation of a winding up petition often acts as a trigger for certain matters. For example, in most, if not all, financing documents, it will be a trigger for default and making any sums loaned immediately repayable. So in both of these cases, the mere threat of presenting either a bankruptcy petition or a winding up petition can be quite persuasive.
What about the situation where you, as the judgment creditor or the plaintiff, has evidence or you have knowledge or you suspect really strong suspicions that the debtor is now dissipating their assets in order to avoid enforcement, or that there's a really strong risk that is in fact the case? What is, if there anything, can the judgment creditor do?
Yeah, so if the judgment creditor has compelling evidence to show either that the judgment debtor is dissipating the assets to avoid enforcement, or that there is a real risk that the judgment debtor may dissipate his assets to avoid enforcement, the judgment creditor may apply for what is called a Margaret injunction to prevent disposal or dissipation of assets. And that may include an order freezing the bank accounts up to the amount of the judgment debt, and perhaps an order prohibiting the disposal of specified assets, including real property and other property. However, there must be really compelling evidence of dissipation or the risk of imminent dissipation of assets. Margaret relief is not available for example, simply because funds in the bank accounts can be transferred out of the jurisdiction easily.
And now we're going to talk about arbitration. In particular, we'll be discussing some of the key differences between arbitration and litigation, as well as some of the main pros and cons of arbitration. I think many, if not most people, have now heard about arbitration as an alternative litigation for resolving disputes. Could either of you maybe tell us about some of the key differences between arbitration and litigation?
A key difference is that arbitration is a private process. So instead of the dispute being heard before a judge in a courtroom, the dispute is decided by an arbitrator or a tribunal, which would normally be 3 arbitrators, who are appointed by the parties, and it's heard in a private venue.
Yeah, I think another key difference between the two is that arbitration is meant to be flexible, and arbitrations can take many forms, which allows the parties to choose the forms and procedures that suit the nature and complexity of their disputes. This can range from relatively simple, streamlined procedures and short timelines for an expedited process to more complex rules and procedures that are better suited to more complicated disputes. I know, for example, many online shopping businesses and travel websites often refer disputes to an expedited form of arbitration. Another key difference is that arbitrations are usually conducted under the rules of various arbitral institutes around the world. For example, here in Hong Kong, we have the Hong Kong International Arbitration Center. In Singapore, there's the Singapore International Arbitration Center. There's the International Chamber of Commerce, as well as the Stockholm Chamber of Commerce, for example.
So it sounds like arbitration would be very, very good for international type of transactions or disputes.
Yeah, it certainly can be.
But otherwise, in general, the arbitration process, in fact, involves many of the same components as litigation. So you have the formal pleadings where the parties set out their respective cases in terms of the claims that they're making, their defenses, counterclaims and replies. Then witness statements and evidence is dealt with more or less in the same way. You have hearings, which are very similar in nature to trials, which would involve the presentation of legal arguments, calling of witnesses, and their cross-examination, and so forth. And then finally, the rendering of a decision, which in arbitrations is usually called an award by the arbitrator or the tribunal.
So in this kind of a situation, then, can parties be forced to arbitrate instead of to litigate?
No. Arbitration is a consensual process, and so that means that the parties must agree to it, whether that's before the dispute arises, by providing in their contracts that in the event that a dispute arises, they must take those disputes to arbitration, and that would be the more usual scenario, or sometimes after a dispute has arisen, the parties can then decide or agree that they will arbitrate their dispute. That's actually slightly more unusual because by the time the parties are in dispute, they normally can't agree on anything. That said, if parties have contractually agreed to resolve their disputes by arbitration, then they can be held to their contractual promise. And so, say a party who's agreed to resolve future disputes by arbitration, if in violation of that agreement they go off and litigate in a court instead, generally the other party can then apply for a stay or even dismissal of the litigation to require that the dispute be resolved by arbitration as the parties have agreed.
I have heard that one of the advantages of arbitration is that arbitration proceedings are confidential. Is that in fact correct?
That is generally correct. Arbitration is a private process which is conducted in private venues which are closed off to the public. In contrast to litigation, which in most cases is conducted in open hearings which are open to the public. The privacy afforded by arbitrations is often seen as a key advantage over litigation, as parties rarely welcome the publicity that comes with court proceedings. So to answer your question, arbitrations are generally confidential. However, when drafting the arbitration agreement, it's always a good practice for the parties to include an express provision for confidentiality in the agreement. It's often assumed by not only clients, but even some practitioners, and I've, in my experience, encountered it with even some arbitrators. They believe that confidentiality is a given. But this is not necessarily the case, and that will depend on the applicable laws and rules that govern the arbitration proceedings. For example, here in Hong Kong, the arbitration ordinance provides for a statutory duty for confidentiality in arbitrations, but this is also subject to certain statutory exceptions which permit disclosure where it's made to protect or pursue a legal right or to enforce or challenge an award before a court or other judicial authority in or outside of Hong Kong. So despite these protections contained in the arbitration ordinance, parties often need to go through the public court system to enforce an arbitral award, in which case confidentiality can sometimes be lost.
So aside from confidentiality then, what other advantages would arbitration have over litigation?
People do often draw comparisons between arbitration and traditional litigation, but to an extent, these comparisons really depend on the nature of the dispute concerned and the perspective of the individuals or companies involved. In terms of these perceived advantages, neutrality is often seen as one. In international contracts, parties are very often reluctant to submit to the jurisdiction of foreign courts for fear of bias. And obviously whether or not this fear is justified depends on the jurisdiction concerned. But that said, neutrality offered by arbitration is often an attractive alternative to local courts and an attractive feature for clients.
Yeah, I think in addition to the neutrality aspect, another key advantage that we discussed just a moment ago is the flexibility. This flexibility afforded by the arbitration process, it really gives the parties a large degree of autonomy and flexibility in deciding how to resolve their disputes, which they wouldn't get otherwise through the traditional litigation system. Another main advantage is that the parties themselves usually get to decide who will serve as the arbitrator, also known as the arbitral tribunal. And this allows the parties to ensure that the arbitrator that they select is suitably experienced and can be trusted to arrive at a sound and fair decision. This enables the parties to appoint specialists who, in many circumstances, will have a better understanding of the industry involved, more so than a commercial judge would. And this can be particularly valuable for international contracts in certain industries such as shipping, construction, intellectual property, banking, finance, etc., where the local courts may not necessarily have specialist courts or judges who are equipped to handle those sort of matters. I think finally another key advantage is the language. Through the arbitration process, parties are allowed to choose the language in which the proceedings will be conducted. And that can often be of a great significance if it involves a cross-border dispute, for example, where the parties don't speak the same language. A party forced to litigate in a foreign country where the proceedings are conducted in the language of that country can often be at a serious disadvantage. So the choice of language can be tailored to suit the common language of the parties.
Okay, so it sounds like there's quite a few advantages. One of you had mentioned that arbitration is actually, in fact, procedurally quite similar to court proceedings. But what about in terms of evidence? Because in court proceedings, that can become quite complicated. Is it the same for arbitration?
Well, the different way in which disclosure of documents is handled in arbitration proceedings is one of the things that can make it an attractive alternative to litigation. So in standard disclosure in litigation conducted in Hong Kong would require parties to disclose all documents which are relevant to all of the issues in dispute. And that is whether or not they're helpful or prejudicial to your own case or support another party's case. And parties also may be required to set out details of all of the searches that they've done to look for relevant documents. And so this can be quite an onerous process, especially when there are lots of emails and electronic documents involved. Arbitration, on the other hand, is much more flexible. And in fact, many arbitration rules only require a party initially to disclose those documents which they rely on to support their case, which is obviously those that are helpful to its case. It's then for the other side to make specific and very focused requests for documents or categories of documents and explaining why their production is necessary. So this more flexible approach to document disclosure is often seen as an advantage. But of course, there can be disadvantages to limited disclosure, because while it can keep costs down, it can also, in fact, make it more difficult to try the case effectively. And a party who maybe doesn't have access to material documents may well be at a disadvantage.
Very good to know. Are there any other key or main big advantages that arbitration has over litigation?
Yeah, I think one of, if not the biggest key advantage of arbitration over litigation is the final and binding nature of the award. generally speaking, arbitration awards are, by their nature, final and binding. And depending on the jurisdiction, there's normally only a very limited amount of time for a party to appeal and very limited grounds for the appeal. So depending on the circumstances, this can be an advantage or a disadvantage. And the finality of an arbitral award prevents further delay and additional costs that will be incurred, by going through the appeal procedure. However, this can be a disadvantage if the arbitrator makes serious errors in the award.
Another key advantage, and for me probably the key advantage, is when it comes to enforcement. Arbitral awards can be enforced under what is called the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and is commonly referred to as the New York Convention. And this provides a relatively straightforward mechanism for the enforcement of foreign arbitral awards in signatory states. And enforcement can only be refused on very limited grounds, mainly relating to procedural unfairness.
So, after all of this, what about the cost of arbitration? Before I even begin an arbitration, I would want to know about the costs, because I have heard some people say that it is cheaper than litigation, while others have told me it is much more expensive. So which is it?
Well, unfortunately, there is no clear-cut, one-size-fits-all answer for that. It is often said that arbitration is quicker and cheaper than litigation, and while this might be true in some cases, for relatively simple matters which can be dealt with, fairly quickly, in many instances, arbitrations can actually be as protracted and even more expensive than litigation. And there are several reasons for this. For example, in litigation, the parties only pay their legal advisor's costs. They don't have to pay the cost of the judge or the court. These are provided at public cost. Whereas in arbitration, the parties do have to pay the fees of the arbitrator or the tribunal, which can typically be up to 3 arbitrators. And that's not including any administrative fees that could be incurred if the arbitration is being conducted under the rules of an arbitral institute, such as the HKIAC here in Hong Kong. You're also looking at fees to book a venue, to conduct the hearings, as well as the costs to have a tribunal secretary present. Poorly drafted contracts and arbitration agreements which fail to provide an adequate framework for the conduct of the proceedings can also increase the time and cost involved. Another issue is tribunals can sometimes be unwilling to control the timetable and the parties' conduct for fear of challenges to any subsequent award on the grounds of unfairness.
So after hearing about all the advantages of arbitration over litigation proceedings, are there in fact any disadvantages that we need to be aware of?
Yeah, certainly there are some disadvantages. One is that arbitration very often isn't suitable where there are multi-parties involved. And so while with careful drafting of arbitration agreements, it is possible to have multi-party disputes in arbitration. But in many transactions where there are several parties involved, problems can often arise where the contracts, or some contracts stipulate arbitration, but others don't, and parties can then end up in parallel disputes in different forums with potentially different results. Another disadvantage is that you don't really get precedence in arbitration proceedings, and this can be important in some cases because the parties may want a precedent that will be followed in a very similar case. An example might be certain types of banking dispute. Given the private and largely confidential nature of arbitration that we've already talked about, awards generally are not published. This means that similar disputes involving, say, a bank with different parties may be decided differently in different arbitration proceedings, which obviously is not necessarily what the bank is looking for, because they're looking for some kind of certainty in terms of how these cases are going to be determined. Those two, for me, are the main disadvantages, but disadvantages that some people talk about is sometimes there's a perception that in arbitration proceedings, the arbitrator or the tribunal may split the difference when making an award. To me, this risk is more perception than reality, and certainly it can be mitigated by ensuring the appointment of an experienced arbitrator or tribunal. And then, as we've already discussed, it's either impossible or difficult to appeal if the arbitrator or the tribunal makes serious errors in its award. And so if you're on the losing end of that, that can be a disadvantage.
I'm here speaking with Matthew Love today about talking about mediation as a form of alternative dispute resolution and what someone who's considering mediation should expect from this process. So, Matthew, what exactly is mediation?
Mediation is a form of dispute resolution in which two or more parties in dispute meet with a mediator, who is a neutral third party, to help the parties try to reach a mutually agreeable resolution of their dispute. Importantly, the mediation process is private, voluntary, informal, and also non-binding.
So how does mediation differ then from other forms of dispute resolution, such as arbitration or litigation?
Yeah, so one of the main differences between mediation and the other forms of dispute resolution, such as arbitration or litigation, is that a mediator, unlike an arbitrator or a judge, does not have any power or authority to issue judgments or awards or even to oppose a settlement on the parties. In fact, the role of a mediator is not to decide who is right or wrong in a dispute. Instead, the mediator is there to help the parties identify the issues in dispute, to help facilitate communication between the parties, which is oftentimes broken down as the dispute has progressed, and help the parties identify and explore, possible solutions so that the parties themselves can reach an agreement, regarding the resolution of the dispute.
Okay, but you mentioned just now that mediators don't have any power to actually decide who is right and who is wrong, or even to issue judgments or awards. So if that's the case, then why should anyone actually attempt mediation? Wouldn't they be better off using arbitration or litigating the dispute?
Yeah, no, I think that's a good question, but there are a lot of good reasons why parties should consider mediation before resorting to arbitration or traditional litigation. For starters, mediation is, generally, but not always, faster and cheaper than other forms of dispute resolution. And this is because there are no set rules as to how a mediation should be conducted. And this, in turn, gives the parties a great amount of flexibility to decide for themselves how to address their specific issues as they attempt to resolve their dispute. Also, as mediation is voluntary and no settlement can be forced on the parties, they are more likely to comply and follow through with any agreement that they're able to reach. Not only can this lead to a faster final resolution of the parties' dispute, which of course can also save on costs, the parties are also able to reach settlement terms that can oftentimes be more practical and creative than the limited range of legal remedies courts can grant.
So it sounds like there's actually quite a few advantages to proceeding with mediation. Are there any other benefits to doing a mediation?
Yeah, I think another huge benefit to mediation is that the voluntary and non-binding nature of the process itself is usually less adversarial than other forms of dispute resolution. And this, in turn, allows the parties, at least the opportunity to repair their damaged relationship, which can be especially invaluable in commercial settings where the parties stand to benefit, often financially, from the restoration of their business ties. The informality of the mediation process can also have numerous benefits for the parties. For example, instead of taking place in a courtroom, which can be quite intimidating, mediations generally take place in a neutral location, such as the mediator's office. And this more relaxed atmosphere can help the parties feel less anxious and defensive and more willing to consider and appreciate the perspectives and positions of the other parties. And when people open their minds to new ideas and ways of thinking, this in turn can increase the chances that the parties will come out of their entrenched positions and start to negotiate with each other in good faith.
So it sounds like mediation would actually also be very good for disputes between family members as well.
Yeah, it definitely can be.
Sounds good. We'd also touched briefly before on the role of a mediator. But how, in fact, is actually the mediator supposed to be selected? Is this done by the parties themselves, or does someone else nominate the mediator?
Okay. So more times than not, at least initially, the parties themselves will nominate and appoint the person or people who will serve as the mediator or the tribunal if there's more than one. And this usually starts with the party requesting the mediation, nominating a mediator, and then sending the nomination to the other party or parties for their agreement. It's also possible for the parties to delegate this process to someone else, an independent third party, but this is rare and usually limited to instances where the parties have attempted to select a mediator on their own, but have found themselves deadlocked and unable to come to an agreement.
Okay, so out of curiosity, though, does a mediator have to be a solicitor or someone in the legal profession?
No, not at all. While it certainly helps more times than not to have a mediator who is, a lawyer or has a legal background, anyone can mediate.
Good to know. So in your own experience, why do parties sometimes find it difficult to agree on a mediator?
Yeah, so I've found that most disagreements over who should be selected to act as the mediator, boils down to a single issue, and that is lack of trust. For example, a party who receives another party's nomination for the mediator might think that, as the nominated mediator was selected by the other party, that person must be biased and, in collusion with the party that nominated him or her. And the receiving party might then reject the original nomination and make their own nomination. And then, of course, the cycle can repeat itself over and over again, and the parties can end up going back and forth until someone relents and agrees to one of the parties' nominations, or the parties find themselves deadlocked, as we discussed earlier, and decide to submit the issue to a third party for resolution. And I find it unfortunate when I see this scenario play out. I do appreciate that the parties in dispute might not trust each other, especially when the dispute has been simmering for some time. But those people who hold themselves out as mediators are usually experienced professionals. Many are former or current lawyers who are very skilled at objectively reviewing the facts and taking into account each party's point of view and position. And this is one area where it really pays for parties to be assisted by an experienced attorney. Not only can an attorney help with nominating mediators who are knowledgeable and experienced with the subject matter at issue to the dispute, a seasoned, lawyer can also help reassure nervous or skeptical clients that just because a mediator is nominated by another party, doesn't mean that they're biased against them or that they will treat them unfairly during the proceedings.
You mentioned just now getting your lawyer to help with finding yourself a mediator for mediation. Do your lawyers have to be involved through the entire mediation process?
Yeah, and that's one of the benefits of mediation is that you don't need a lawyer at all, actually. While I would always recommend a party be assisted by an attorney, if lawyers aren't required to participate in the process.
So after all of this, settle your mediator and you've finally agreed to mediation with the other side, how long will the whole entire process last?
Again, as with many aspects of mediation, there is no one-size-fits-all standard when it comes to how long a mediation will last. That will very much depend on factors like the nature and complexity of the dispute, the number of parties involved, etc. However, it's not uncommon for mediations to last only about 1 to 2 days, as this is often enough time for the parties to hear each other's positions and try to find common ground in order to come to a mutually agreeable settlement. I usually don't advise clients to agree to only a half-day mediation session. In theory, a half-day session is certainly possible, but in practice, it usually takes most of the morning for the parties to warm up to the negotiating process and start to move away from their entrenched positions. That's why I always advise clients to schedule at least one full day for the mediation session. In my experience, it's much better to schedule a full day and then be done early than to have to end the session prematurely and then go through the process again at a later date. No one likes that.
So what if even after the one full day of mediation and there's still more to discuss, could you go and do multiple sessions or further sessions?
Yeah, you definitely can, assuming the other parties agree. But, again, the mediation process is not something that most people enjoy. And so if you're going to do it, you should try to knock it out, as soon as possible and in as few sessions as possible.
I suppose a mediator's job would also be part of trying to help time management for the parties.
Exactly.
Good to know. So we've talked about some of the advantages of mediation now, But what if the parties are not able to resolve their dispute via the mediation session or sessions, and they proceed, in fact, instead to traditional litigations? Can the parties use what was said during the mediation against each other in court proceedings?
Yeah, that's a really good question. As civil litigation cases in Hong Kong can generally take about 2 to 4 years, on average, to complete, the courts want to encourage parties in dispute to try to resolve their issues by other means, not litigation. And that's why what the parties say and discuss at the mediation are on a without prejudice basis and are confidential. Specifically, the Hong Kong Mediation Ordinance states that any what they call mediation communications, and that includes anything that is said or done, any documents prepared and produced, or any information provided for or in the course of the mediation are confidential. And what this means is that, with some exceptions, parties generally can't use what was discussed or produced at the mediation against each other later on, such as during litigation proceedings. And this is done to encourage more parties to attempt mediation first before turning to the courts, as it gives the parties at least the option to try to resolve their dispute without, in theory, having to worry that making a good faith effort at the mediation will result in their good faith being turned and used against them later on.
Okay, so given everything we've discussed just now about mediation, what any other pieces of advice that you would like to have for our listeners who may be considering mediation to know about things they need to know to maximize a chance of a successful outcome?
Yeah, so just in addition to what we've already discussed, one thing that still surprises me is the number of companies that send representatives to the mediation, where the party is a business, who don't have the decision-making authority to actually enter into any settlement agreement on behalf of the party they're representing. And frankly, that's just a big mistake. Sending a representative with actual decision-making authority not only shows the other party or parties that you're taking the mediation seriously, it also allows for resolutions to be achieved on the spot, while the parties have the advantage of a neutral and skilled mediator present to help with the negotiations.
So thank you, everyone, for tuning in to listening to this episode on dispute resolution, and we hope you join us for our future episodes.
Be sure to catch our other episodes of the Hip Talks podcast by checking the Insights section of our website at www.hugillandip.com. And please send us your comments by writing to our email address hello@hugillandip.com. Also, please feel free to share this episode of the Hip Talks podcast with your friends, family, and associates. For the hearing impaired, you can find the notes and the transcript of this episode on our website. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.